Yes. Hello, my beautiful friends. What an amazing day it is. We have a tremendous live stream planned ahead. We've got a big update where the Democrats are seemingly getting a little bit nervous. They're listening to the president talk about perhaps an election national emergency, and they're having a meltdown all across the internet, sharing this clip around like wildfire. Trump didn't even really say that, but kind of hinted that stranger things have happened before, and so maybe we'll get something coming up very soon. If the Senate won't pass the SAVE Act and we can't get any election integrity to happen, maybe the only option is for the president to take decisive action. So we got the clip, we got reaction, and they're referencing another Supreme Court case back from the 1980s. We'll take a look at that and see exactly how this whole thing could unfold if the president were to do something like this. We've also got some other updates. Remember the New Jersey illegal aliens on the voter rolls that are being hidden by the governor, Mikey Sherrill. Well, we've got now more investigations launched by Congress, not only into, as we've seen before, the actual state, but now they're going after the so-called software company, the vendor, to say they're pointing their fingers at you, blaming you for all of this. And so now we've got questions for you. We'll take a look at that. Then we had a big victory out of the D.C. Circuit Court of Appeals, backhanding and slapping down a Biden judge, Gia Cobb, also known as Gia the Cobb. And we'll see exactly what she got so wrong and why these fast-track deportations can accelerate and we can FOIA a bunch of these people on out of the country. Then we're waiting on the Tyler Robinson defense brief. It is supposed to be due today, presumably by 5 p.m. And we've got a couple of hours until it drops. And so if anybody sees it out there and has the link while we're live, we'll jump into that as well. Otherwise, if it doesn't drop, then we've got a backup plan. But we've got a great stream planned ahead. We want to see what Tyler Robinson's defense team says here as they fight over probable cause in the aftermath of the preliminary hearing. And we're excited, of course, to hear from you at the end of the stream. We had a beautiful members only stream this morning as well. And of course, we'll come back to that and hear from you at the conclusion of today's show. But we got some business to attend to here today. So let's confirm that we're coming across loud and clear. It looks like we certainly are. Amazing when that happens. So let's go ahead and get started, shall we? Democrats now panicking after the president hinted that he may declare a national emergency for America's perverted and rigged elections. A short little clip where he said, you know, stranger things have happened. I'm not necessarily arguing that I'm going to do this right now, but it could happen because perhaps stranger things have happened before. Didn't even say it, but they're melting down all over the place. And we've got the clip. Of course, we've got the democracy docket dorks over there saying Trump is now signaling an openness to an unconstitutional plot to take over elections. And all of the big accounts on X that are on the left are all just going hog wild with this thing, sharing it, reposting it. He's going to seize elections. He's going to steal the midterms and so on and so forth, even though we know that the Democrats are perverting the voter rolls. We've got now new letters that have been fired off by Congress over to IDEMIA. This is the company that was so-called responsible for the glitch out there in New Jersey. And a new investigation launched by America First Legal into New Jersey, demanding basically under state FOIA rules, the records so we can peer inside and see exactly what's going on. But this is the clip that's capturing a lot of the attention out there from one individual on Real America's Voice talking to the president, sharing with him this idea, and we'll unpack the idea to see how this whole thing could unfold. But here's what the president had to say in this very short clip.
A lot of people get it. So let me put an idea in your head, okay? Because it's so hard to get the Senate to do anything. Now they're on recess. They don't get anything done. True. If they never get the Save America Act done, you have the right to declare a national security emergency for elections. And the Supreme Court ruled in 1983 under Reagan that INS versus Chadha, that if you declare a national security emergency as the president of the United States, they can't challenge it. It can only be overturned by a 2/3 vote of both houses of Congress. So if you do this in the next month, we will get photo ID, proof of citizenship, and a limit to mail-in ballots, and you don't even need the Senate vote.
Happened. Okay, I'll leave it at that.
Oh,
All right, we'll leave it at that.
stranger things have happened. We'll leave it at that.
Ballots, and
Let
you
me
don't
just
even
say that
need
stranger
the
things
Senate
have
vote.
happened. Okay, I'll leave it at that.
Oh,
All right, we'll leave.
So that's the little comment heard around the world, and they're not happy about it. Democracy Docket came back out and said he's going to declare an emergency. He's willing to do this in an attempt to take over American elections. And they wrote a whole article about it. He's got no power and more. But you heard about that case that the president referenced there. And we'll take a look at it because there was this article. This may ring a bell for you. If you recall back during Trump 1, there was an idea of declaring a national emergency at the border to say we got to actually send some more cash down there to build a border wall to stop the invasion that was happening. And the Washington Post walked us through this 7 years ago. They said how the Supreme Court in the Chadha case stripped Congress of the power to end national emergencies. And so just sub out the border wall in this article for an election emergency on a national level, saying the House voted, this is 7 years ago, on Tuesday to disapprove of Trump's emergency declaration. Okay, so Congress says you can't do that, Mr. President. And they're going to redirect defense funds from the president. They said you can't do this. The Senate will soon take up the question. Now, the question that they were investigating is whether Congress's actions make any practical difference. So by a simple majority, let's say Trump does come out and declare an election national emergency, what can they do? As we just heard, it's got to be a 2/3 joint resolution, and it's got to actually be both houses. It needs to be a lot more substantive than just saying we disapprove. The answer is almost certainly not. Can they do anything? That is because ending the emergency declaration requires a 2/3 supermajority in both the House and the Senate to overcome a nearly certain presidential veto. So they could go and pass a joint resolution, send that over, get past the filibuster and all that, send it over to the president, but he'll just veto it. He'll say, no, I'm declaring a national emergency. And your joint resolution to undo it, vetoed. Get out of here. So to override the veto, they needed the 2/3. So to put it mildly, they wrote back then that reaching that threshold is extremely unlikely. But the original 1976 law did not allow a president to veto emergency powers. But then the Supreme Court came out in INS versus Chadha, and it stripped Congress of the ability to unilaterally end a presidentially declared emergency. And as a result of that decision, Trump could make a declaration with little fear of any congressional pushback. Aha. The court, in effect, created a new presidential power that, as we're seeing now, poses a significant threat to the rule of law. Sounds like it is the law. How is it a threat to the rule of law if the Supreme Court said this is the law? It's not a threat to the rule of law. You may not like it, but that's what the law is. That's why we have the Supreme Court and we have these bodies that will actually articulate these separate branches of government that will kind of do this infighting to come out to the conclusion about what the law is and what it says. Now, the highlights of this, they had California, ACLU. They wanted all of this declared illegal. But when the National Emergencies Act was created in 1976, they wanted to impose some order on the president coming out and declaring national emergencies. The act terminated all emergencies that were in effect, required the president to follow certain procedures and more. Also, it was patterned on the 1973 War Powers Resolution, which places checks on the president's power. But then in 1976, Congress seemed on firm ground using a concurrent resolution. And the first veto was included in 1932 when Hubert Hoover used it. And a lot of time has gone by. But in 1983, the Supreme Court in INS versus Chadha invalidated the legislative veto. And all legislative vetoes. This gave the Immigration Naturalization Service the power to decide whether to deport unauthorized immigrants. And they invalidated the veto on the theory that the veto had the purpose and effect of altering the legal rights, duties, and relations of persons, and Congress cannot do that. So it invalidated hundreds of provisions of federal law. And now the new theory is that Trump can declare a national emergency. Whether he does or not is, of course, still to be seen. And I have my doubts about it. But the argument is he could, and then Congress really couldn't do much about it unless they hit the 2/3 veto-proof majority to override any veto of a joint resolution that they would pass in order to undo the national emergency. So then after Chadha, Congress amended this so they can use a concurrent resolution to end an emergency. It's by a joint resolution, but this still gutted the original act. And of course, the resolution would go to the president, he'd veto it, and they'd have to override that. So it is possible, my friends, and the president says stranger things have happened. So maybe we'll see something like that coming down soon. But meanwhile, the Democrats are very nervous about this. And you can see Kamala Harris is explaining why they're so panicked. She posted this, it looks like over on her Instagram or X or somewhere. Very short clip because we can only lose so many brain cells listening to this woman. But here is what she had to say.
Basically would require that for people to register to vote, you're going to have proof of who you are.
Oh, wow. That's the whole point. We want actual people that we know and are legitimate to vote in our elections, but she's like sharing it like it's shocking news. I know you're a Democrat. You should be able to vote 100 times. And if you have to validate who you are, that's going to be devastating to our electoral prospects. So while all this has been going on, we have a lot of questions about who is actually voting. In fact, in New Jersey, we saw that there were over 6,000 people who were non-citizens on their rolls, 400 of whom actually voted in elections. And now the GOP on the Judiciary Committee is going after the software company. They've already launched into New Jersey itself, sent a bunch of letters over to Mikey Sherrill, who then turned around and said, get out of my life and I don't want to talk to you, and pound sand. But now they're going back over to the company. They're saying, well, the state is blaming you. So we need to hear from you. What's your position? Now we've got new letters going over to IDEMIA, demanding information about thousands of non-citizens who are on the rolls and many of whom actually voted. Using IDEMIA's software, non-citizens noted that they were not citizens, but did want to vote. And New Jersey state agencies had this information and proceeded to register 6,000 about non-citizens to vote anyway, and hundreds did vote, and we need to know more. And this is only the people who flagged themselves and said, actually, I'm not a citizen. I checked the box. I don't want to vote. Don't include me in registration, because if I vote illegally, it might really jeopardize my immigration proceedings. They might ask me a question. If you voted, I'll say no. Turns out I did, or I was registered. It may kick me out of the whole entire process. So they have flagged themselves as no, don't include me. What about the people who did not flag themselves? Okay. So in other words, New Jersey has a whole list of submissions that came in. And one bucket of these submissions has a group of people who said, count me out. But there's probably another bucket that didn't say that. And what has been done with them, nobody knows. So letters have been flying out, and you can see this one dropped today going over to IDEMIA, the CEO. The guy's name is Mr. Matt Cole, and it's from the Judiciary Committee. They sent another one to Harmeet Dillon. So we've got Jim Jordan, Brian Steele, Laurel Lee, and Jeff Van Drew, 4 of them, Judiciary and House Administration, kicking this off, saying, all right, Mr. CEO, the Committee on House Admin and Judiciary are charged with upholding American civil liberties and the integrity of our elections. On July 21 this year, Mikey Sherrill announced that about 6,600 non-citizens were registered to vote in the state between June 23 and June 24. 1 year. And we know that a lot of this automated system was created back in 2018. So where are the other people? And why have they not been disclosed or investigated? And that hundreds of non-citizens had actually voted. They refer back over to the YouTube video where Mikey came out and held a whole press conference about it and admitted everything. Using IDEMIA's software, the State Motor Vehicle Commission sent information of non-citizens to elections departments there, and the non-citizens were registered to vote. Then Sherrill blamed an error on you and pointed their fingers at you. However, IDEMIA has publicly denied that its software was the cause of any of this. They said, we just take the orders. You have to process them. We just say, what would you like? Take it back to the chef. The chef makes the food. If the chef screws it up, it's on them, not on us. We deliver the order appropriately. However, IDEMIA has publicly denied that its software was the cause of this also. Now, to further our oversight, we write to request information about what happened here with your software. And according to the governor, who doesn't want to take the blame, quote, a serious software error in the motor system led to the improper voter registration of about 6,600 people. And Homeland says it's much higher than that, about 35,000, give or take. Now, Mikey claimed the error affected individuals who indicated, so the question is, if you indicated I'm not a citizen and they added you anyways, is there any check on the system at all? What if you say, I am a citizen, even though I'm not? Do they validate that in any way, shape, or form? No one knows. And they weren't eligible to vote, but the software threw them in anyways, is what she said. She said that the issue lasted from June 23 to 24, and then, quote, the software was corrected, and didn't want to identify anybody who was responsible inside the state government. Of the 6,600 non-citizens, about 400 of them voted. Harmeet said, we'd like to know who they are. What nation did they come from? What election did they vote in? Who are they? Because we may want to charge them with federal crimes. It's illegal to do that. And they may not have been responsible for actually getting on the registration list. Maybe that was actually an error from the state that they're not responsible for. They said, I'm not a citizen. You put me on there. Don't blame me. But if you got a ballot and you cast a ballot, okay, you know clearly because you check the box that says I'm a non-citizen, don't send me a ballot. They did send you a ballot and you voted it anyways, or you went in person and submitted a ballot. That is illegal. And there's strong intentionality behind that, given the fact that in your file, you said, don't send me one. They voted anyways after they were incorrectly registered. And they probably would have gotten away with it too if it wasn't for those meddling DOJ attorneys and the Trump admin. So IDEMIA came out, the company, and they refuted Mikey's claims. They said, it's not our problem. Our software was not the cause of these improper registrations. It's the state agencies. And as IDEMIA explained, all 6,600 individuals indicated yes to wanting to register to vote and no to being a U.S. citizen. So they actually did say, we would like to vote. That information was recorded correctly and always available to the New Jerseyans via the database that they utilize to gather voter information and to transmit it back to the Division of Elections. And according to you guys, Mr. CEO, the registration of non-citizens appears to have ended only when the MVC asked IDEMIA to change certain settings in June 24. But the non-citizens were not removed from the voter rolls, and the issue was not publicly disclosed until July 2026. And really, if Trump and Harmeet and the DOJ had not been kind of breathing down their necks, shaking them loose, saying, we're literally going to prosecute you, okay? If you don't clean up your lists and you enable illegal aliens to get on the rolls and vote, we're going to charge you with crimes because your whole job is to prevent that from happening and to maintain the integrity of our elections. So based on this information, the committees are concerned about the application of federal law in New Jersey as it pertains to accurate voter rolls. We've got laws about this, as well as the effect of New Jersey's failure to identify and even remove these peoples from their rolls, and what that does to the civil liberties of American citizens. Every one of those 400 voters canceled out somebody else's vote. Now, they may not care about that because it's canceling out probably a right-winger's vote. Somebody who is a little bit tougher on immigration, you would presume that immigrants who are here are voting for the party that's going to facilitate their immigration proceedings, and that's generally not Trump, and their ability to elect their representatives. Now, as the vendor that provided the software, you guys, that allegedly made this error, being blamed by Mikey, IDEMIA has relevant information about the nature of the error and the information collected by your software that New Jersey had in its possession, including how IDEMIA communicated with New Jersey state authorities about fixing the error. We'd like to see all of those emails. And to further our oversight and to inform our legislative efforts to fix and secure our elections, we'd like to get the following information from you going all the way back to January 1, 2023. And as I mentioned, there's other reporting that this all got started in 2018. So we want all documents and communications about the so-called software errors that resulted in non-citizens registering to vote or the transfer of non-citizen data resulting in voter registration. We'd like to know about the discovery of this registration up into and including any investigations related to what happened. We also want all documents and comms referring to or relating to your protocols about this. What are your systems, your SOPs? How do they govern the accurate collection of this information? Specifically, how do you transmit it to them in New Jersey and more? And we all want all documents and communications referring or relating to your protocols about how you comply with federal voting laws, if you do at all. All documents and comms between or among IDEMIA staff, anybody on your team who worked with New Jersey officials that refer to any of this. Anything used at the Motor Vehicle Commission to help register these people to vote, including comms at the time of the discovery of the error. Any potential warnings, did you tell them, hey guys, you're not handling our handoff appropriately? and any discussions relating to the remediation as well. So emails back and forth, send them to us. Please produce these things no later than August 25th, so a couple of weeks from now. And pursuant to the rules, as you know, we're Congress. We have a lot of power to do a lot of things and to investigate multiple areas. Any questions about this, give us a call. Otherwise, get copying the files and FedEx them with haste. Sincerely, your friends on Judiciary and House Administration. Now, Harmeet got one too. And you see this one is sent to them at the Civil Rights Division by the same individuals down here. Another short one saying, all right, listen, Harmeet, we are conducting oversight about how hundreds of non-citizens actually voted in an unspecified number of U.S. elections back during Biden and Harris. In light of this new information, the committees are concerned that Democrat-run states may not be complying with the Civil Rights Act and are undermining American elections. Your concern is valid. It's a good call. We appreciate the DOJ's commitment to the fair and unbiased enforcement of federal civil rights laws, and so we respectfully request a briefing about this matter. And the brief is pretty simple. Harmeet sent a letter saying, I'd like information about these lists, who was on the list, who voted, what the problems were. And Mikey said, no, I'm not giving them to you. I'm going to invoke privacy rights of non-citizens, suspected criminals, who the governor admitted committed federal crimes by voting illegally in elections. So she's protecting people that have probable cause to support criminal charges and who actually voted in elections. On July 21, Mikey announced that 6,600 non-citizens were registered, again, for that 1 year, and that hundreds, up to maybe 400, had actually voted. They blamed the software IDEMIA, saying they gathered the information, they sent the information to New Jersey elections, and then they were registered. Mikey blamed the error on the software, but IDEMIA has publicly denied any responsibility. We didn't cause it, it was them. Now, IDEMIA has refuted Mikey's claims that the error was the cause of the registrations, and they blame New Jersey. As IDEMIA explained, all 6,600 people checked the box yes to wanting to register to vote, which is another concerning thing, right? And that's a little bit new information. So they say yes, even though they're non-citizens, they should know that the answer is no. I'm not allowed to register to vote. And so what validation was happening for people who said, no, don't register me? Were they being processed? Were they being registered? And no to being a citizen. They didn't check. And it's like the most obvious logic chain just got completely breached, and they just put them on. That this information was recorded correctly and it was always available to them. And so somebody was just basically following the second checkbox or the first checkbox. Oh, you want to register? Perfect, you're registered. I don't really care if you're a citizen. Sounds like user error back at the government level. And this information was always correct. We gave it to them appropriately. According to them, the non-citizens registration problem appears to only have ended when New Jersey came back and said, can you guys change certain settings so you don't send us this information? But the non-citizens were not removed from the voter rolls. So as far as we know, they're literally still on there. And the issue was not publicly disclosed until July 26 under threat of criminal prosecution. And again, it's a limited hangout. There's a lot more to this, which is why they didn't come back out and investigate the prior years. 1 year, that's all we got. There's more. Homeland knows there's more. They can't admit the full extent of the fraud that's actually going on. So they just gave us a little bit of a nugget and said, okay, we fixed it, move on. So in order to protect the integrity of America's elections, Congress says it is paramount to ensure compliance with laws. The committee is concerned that the laws are not being appropriately applied there, and this has effects on American voters. It dispossesses un-American for every illegal vote. Civil Rights Act literally requires states to maintain voter records and empowers the DOJ to vet these lists by cross-referencing the list to identify improper registrations. And accordingly, we want a briefing from you to tell us how you are ensuring that states comply with federal voting laws. And Harmeet is trying. She's suing all over the place to get these lists, but the lower level district judges are preventing her from doing that, saying state privacy laws, long story short, there's like 17 lawsuits that the Civil Rights Division has lost across the board. But they're saying, the judges, that she doesn't actually have that power, and that there are a couple of arguments that are ultimately being made. One, privacy rights, and the other big one is about the actual records. They're saying the DOJ is requesting things that they're not entitled to. The state lists don't actually fit the definition that Congress passed that enables them to get their hands on the record. They say it's like work product. Well, we made the list, and so we don't have to give it to you because it's not a federal record, it's a state record. So pursuant to all of the House oversight power and criminal law and national security, hint, 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 national emergency, to schedule the briefing, please contact us at the following numbers. Sincerely, your friends, Jeff Van Drew and others in Congress, and obviously copying all the Democrats there as well, who are perfectly happy with fraud because that's how they win. So that went down. And now we've also got America First Legal. We know who they are. And they sent another investigatory letter into New Jersey. So we're going now after, and Congress has already sent a bunch of letters into New Jersey. We covered those a couple of weeks ago. But we also have now these, kind of third parties who are also inquiring into what New Jersey is actually doing. And they're using open records and public records requests in order to do this, saying the software glitch is not actually a software glitch. It's a problem. And they blamed a vendor error on this. And so we're trying to figure out what happened, saying we now seek notice and want the notices that were provided to aliens who may have ultimately been on the list. And so the state did send out a bunch of things saying, oops, we accidentally added you. And here's what they sent over to New Jersey. They said, all right, this is America First Legal here. And we're a nonprofit working to promote the rule of law. And we got some questions for you there. Pursuant to Open Public Records Act law in New Jersey, we want the following. All comms between elections, Department of State, motor vehicle, Mikey's office, chief counsel, and IDEMIA. Any emails, Open Public Records Act says we're allowed to look at these things. You should be using your official emails. And so copy those and send them to us. Also, anything about who is responsible for registration, any software errors, and cooperation with Congress and more. Any notices, any demands going back January 1, 24, all the way to present. Similarly, all records about error reports, system logs, citizenship status indicators, anything about who was registered between June 23 and June 24 as well. We also want all records about which primary, general, municipal, school board, special or federal elections that these people voted in, whether a race was actually decided by this, and the number of unlawfully cast ballots in each jurisdiction. And we just saw a race, I think it was out of Indiana, where a lady won by 3 votes. Current and prior contract statements of work and service level agreements between New Jersey and IDEMIA. Who was responsible for verification? Who validated the data? Who would adjudicate citizenship responses? Somebody says, I'm a citizen. You check and say, no, you're not. What's the procedure for that? And all records of any quality control, audits, certification requirements, any internal communications about a software error or a glitch or a vendor failure. Similarly, all records reflecting the countries of citizens who came in and voted illegally, and whether certain countries or certain groups account for a disproportionate share, like is it all the Somalians, for example, who are voting. Any notices or demands where IDEMIA disputed that it was our fault. Anything about notice provided to the affected individuals. So once you discovered this, what'd you do? You sent them letters. We want a copy. All records about administrative, technological, contractual, or other changes planned to prevent this from happening again, and to stop people from being illegally registered in the 2026 general election, which is coming up in months. We want a waiver of all fees. This is a nonprofit. Don't charge us $1 million to go and find these records. We're entitled to them. And so if any portion of these records are withheld, we want to know exactly why. Cite the specific exemptions that you claim in order to withhold this stuff from us. And otherwise, please produce all non-exempt portions of the responsive records. Sincerely, your friend, Will Scolinos at the America First Legal Foundation. And we know what's going to happen is obviously they're going to deny all of that and say, we're not giving it to you. And then the next step after the demand will be a follow-up lawsuit, and then we'll get into the weeds and we'll have to adjudicate this whole thing in a court of law, which we're looking forward to. So that's being started by America First Legal. We love are legal entities on our side of the aisle who are pushing back against the democracy docket dorks who are constantly suing everywhere. This is a good vector to unpack, and we're happy to see that it's happening. Now, Trump was saying back on that same interview that really what we want is the Save America Act passed. And if we can get that through, a lot of this would be solved, which is why they don't want it to go through. Here's the president.
The Senate has to get going on Save America. I really believe that because people expect that to happen, and it has to happen. And you have a couple of Republicans who aren't voting for it, a few. You know, it's about an 89% issue with the overall population, including Democrats. Save America is voter ID with photo, by the way. You know, it's nice to have they're fighting on the photo. We don't want a photo. Now, why don't they want? Because they want to cheat. You know, it's very simple. There's only one reason. But we want to have that. We want to have proof of citizenship. So be nice to say, yes, I'm a citizen. Here's my citizenship, proof of citizenship. And ideally, but we're not even stressing this because that's only a 79% issue. You know, that's not in the 90s. The mail-in ballots are so corrupt. You know that.
Right.
They're so corrupt. The Senate.
Very true, Mr. President. And of course, the Senate is gone. They all dropped the ball on their way out of town to go back home and wrap up the summer in their home districts and their home states. But even if the SAVE Act can't get passed and implemented for this midterm cycle, we'd like to see the Senate do it and the House do it with haste so that we can get it all rolled out before the 2028 general election at the end of the day. So we've got a potential, perhaps stranger things have happened when it comes to declaring a national emergency. Of course, we have our doubts about that. I think the political blowback would be explosive, even though it is a national emergency. They had a full White House press briefing explaining that China is hacking the voter rolls. We've got IDs being imported in. We have our own intelligence communities covering up any actual foreign nefarious actors. We've got hacks that we talked about of Arizona data where just random hackers can go and siphon off all the voter registration data, exploiting URLs in the various systems. And we got a lot of problems here, including working IDs that were imported from China that actually validate when you scan the barcode. So we do need to fix this. We're happy to see some updates on this. And once the facade starts to crack a little bit, you can start to peel the layers back and get to the root of what's actually happening. So we'll keep our eye on this one. Thank you for joining and subscribing as we do. Now, let's turn our attention to another big win. In this case, we have victory. Court of Appeals just slapped down a Biden judge saying that she overstepped her jurisdictional boundaries. And of course, this is a very common thing. We have lower level judges in this case called Gouveia the Cobb. She was appointed by Joe Biden and she's in DC at the lower level. And of course, they like to effectuate their policy using their judicial robes to bypass and strip away the rights of the American people who do not want these proposals or these policies to be implemented. That's why we voted for the Trump administration. But in this case, of course, what we're seeing is there is a coalition of Democrats for humane immigrant rights. And they sued Kristi Noem a long time ago. And what Gouveia the Cobb did is she blocked the Trump policy that said we can expedite deportations for non-citizens. They come in, they claim that they've got endless rights, due process proceedings, and they have constitutional prerogative and more. And you can't do anything, even though they crapped all over the Constitution and the rule of law by coming in illegally. You can't get rid of them. So here, of course, we saw big shout outs and celebrations from Homeland Security. James Percival, the general counsel over there, said big win in the DC circuit, preserving our full expedited removal authority. Let's go. It's not too late to take a $2,600 check and a free flight home. We'll even give you a little Sprite on the way home. Would you like another Sprite? Enjoy it because you're going to have to pay for it moving forward. And another celebration from Brett Shumate. He said, boom, the DC Circuit has affirmed Homeland's authority to use expedited removal for former parolees. Case has been litigated since the very start of the administration. And this is part of their strategy, right? It's have a Gouveia the Cobb come in and block it. so that you can't do removals. It's now August 2026. So she entered the stay long time ago. We have to go all the way up to the Court of Appeals, litigate this whole thing, and almost a full year has been stripped away from us because the COB has decided that they are going to block the efforts of the president. But the decision came down, and you can see it's a good one, decided today, fresh out of the oven, explaining, all right, this group, the Coalition for Humane Immigrant Rights, and it was a bunch of these other groups. I mean, these groups are wild. I think there was a interesting one here. Yeah, the UndocuBlack Network. Hadn't heard of that one before, but the UndocuBlack Network. All right. We also saw CASA. They come skidding in for everybody. And another LA group, they all sued in DC, and Gia the Cobb granted their request at the lower level. And now she's vacated. And she knew she was going to get vacated, but she was delivering a political win. So here's what we got. You see from the court, the decision of the court in a per curiam manner, which is saying that it's the decision of the court. No particular judge is taking the decision, saying leaders in Homeland Security issued a memorandum and sent an email saying that officials should consider subjecting parolees to expedited removal. Okay, Trump came in, Noam came in, they said, you're gone. We're going to expedite this. We're not going to just stall this out. Several parolees from the UndocuBlack group challenged the legality of the memo and the email. But the parolees did not challenge the authorities that permit the government to subject them to expedited removal. Oops. So you sued making one argument, but you kind of missed the point. And so the question here is whether the organizations have standing to challenge the governmental action in order to avoid the expedited removal of their individuals without showing that the requested relief would likely leave their members less liable to expedited removal. Can you even be here? Answer, you do not. No standing for you. And so get out of my courtroom, and we're going to pick up the removal pace and expedite it with haste. Here's what they say. Now, each year, Homeland Security reviews thousands of applications by immigrants for parole. Parole, what that means, it's a form of permission to be in the United States, to enter in. Although parole permits temporary entry, it is not deemed as admission of the alien. Okay, you're here temporarily. We're kind of letting you be here on parole. Think of it like getting out of prison, being on parole. Don't screw up. It's temporary. We can remove you. It's not more permanent admission. Now, like other aliens who have not been admitted, parolees, just a separate category, we make it so complicated with all these different buckets of non-citizens who are here. Visas and TPS and parolees and admitted and then outright bona fide illegals, so that nobody knows what the hell is going on. But this is another group. Now, parolees may be removed from the U.S., although the procedures for removing them are not always the same. Some parolees may be subject to formal removal proceedings. Those can take longer and give more procedural protections. Now, others may be subject to expedited removal and move more expeditiously and provide fewer procedural protections, citing a bunch of case law here. Now, one authority that may permit expedited removal is especially important here. It's 8 U.S. Code 1225, which we call the arriving in authority, arriving in the United States. It allows Homeland to use expedited removal for procedures for aliens who are arriving in the United States. Now, under implementing regulations, first promulgated back in 1997, less than 6 months after the passage of the statutory arriving in authority, where they wrote, an arriving alien remains one even if paroled. More laws being cited, they explain that's what we're basing this all on. Now, when Trump took office a second time, his administration sought to subject these parolees to, quote, expedited removal. You have to go home. Two particular measures matter for understanding our decision today. The first one came out January 23rd, immediately, 2025. This guy called Benjamin Huffman over at Homeland directed immigration officers to consider whether expedited removal should be applied to anyone who is amenable, including those who have active parole status. That's called the Huffman Memorandum. Okay, just a document. The The second is the ICE email. Then soon after the memo came out, there was an email. February 18th, ICE agency circulated an email saying that officers, now you're actually processing these people, may process for expedited removal any arriving alien, including paroled arriving aliens. So put them on the fast track list. The Coalition for Immigrant Rights, Humane Immigrant Rights, and two other membership organizations like the Undocu Black, they sued under the APA, which is the catch-all provision that we see a lot of lawsuits filed under, and the Due Process Clause under the Fifth Amendment. So now you're here as essentially a parolee as a guest, and then you cannot be removed because it violates your constitutional rights. Insane system. So they also moved to stay the challenged actions under U.S. Code. They did not move for a stay, though, under the Code of Federal Regulations. That is the regulation that subjects the parolees to expedited removal under the arriving in authority. So we're chaining a couple laws together. And as we talk about, you've got the Constitution, the supreme law of the land, and you've got Congress, which passes statutes, which creates our U.S. Code. Then after that, we interpret the code with the CFRs, the Code of Federal Regulation. And then you can challenge the various regs, saying, well, that's not really what the law says, and so we want to sue under the regs. The district court, Gia the Cobb, she granted a stay to the extent that the actions subject to expedited removal individuals who have been at any time paroled in the United States at a point of entry. Okay, so she blocks everything. So we, though, hold that Gia lacked jurisdiction, and so we vacate her stay, and she loses. So the only questions that we address today are about jurisdiction, both our own and Gia's. Although we have jurisdiction over this appeal, she did not. She lacked jurisdiction to even do what she did, but she did it with haste and stalled out these fast-track removals. We begin with two challenges to our jurisdiction. The first involves our appellate jurisdiction over executive action. And certain actions generally are not within our jurisdiction. We have jurisdiction over final decisions of the district courts, right? This is a court of appeals. They can't just on their own, sua sponte, say, well, we don't like what Trump did over there, so we're going to block it. No, there's got to be a case in controversy. Somebody needs to sue. It's got to work its way through the lower level courts and then emerge up to the top where there'll be a decision from the Court of Appeals that's only connected back to the actual underlying litigation. And continues, now it's unnecessary to decide whether a stay of executive action qualifies as an injunction. And according to our precedents, the practical effects test is satisfied if either the order affects the merits or there's an irreparable consequence and more. And here, the stay from Gia the Cobb, she knows that she can't grant a universal injunction anymore, so she just stays the Homeland memo and the Homeland email. But in practical effect, it was an injunction. Now, as the prior panel of our court suggested when analyzing some of the very actions at issue, the stay is immediately appealable because it might have an irreparable consequence, and we can only remedy that on appeal. Saying we got to start first with irreparable injury. Now, as we explained below, the government and America was injured by Gia's order, which was the whole point. That injury was irreparable because the government says the lower court wrongly issued, again, universal relief, which they're prone to do. Exercising general oversight over the executive branch, improperly intruding upon its prerogatives. Trump versus Casa at the Supreme Court said you can't do that. And she did. And moreover, even if the universal relief were not involved, the injury inflicted by the stay would be irreparable because the executive branch policy at issue has foreign affairs implications, which are in the purview of the president. Now, any policy about aliens is vitally and intricately interwoven with conducts and relations with foreign powers. So that also explains why the stay order can be effectually challenged. Now, they're saying, you can't even hear this because it's not a final order. It's not a final injunction. It should be litigated down below. And the government kind of appealed this thing up rapidly in an interlocutory appeal, kind of bypassing, saying this is ripe for appeal. We need you, Court of Appeals in DC, to step in here. And the court is saying that's right. When it comes to the irreparable injury inquiry, in interim relief, since we're appealing just from a stay, not a final order, the very question is whether relief is needed to preserve the court's ability to grant effectual relief later. So it is unsurprising that in the Supreme Court's most recent foray into the test here, the court collapsed the irreparable injury prong and this prong. And so our decision today accords with the decisions of our sister circuits as well. Other circuits have also held that 705 stays are immediately appealable. Even a few months ago, a panel said it was aware of no court of appeals saying that stays are not appealable. So this should not be surprising. Okay, the practical effects test is concerned with, well, practical effects. And as the Supreme Court explained, both stays and preliminary injunctions have the same practical effects, and so we can actually hear this. Now, the second challenge involves the government standing to appeal. The challenge to the government standing to appeal arises ironically from the government's argument that they lack standing. To oversimplify a bit, the court writes, the government's challenge to the plaintiff's theory of standing is that the plaintiffs sought to stay only the memo and the ICE email. But staying those two actions could not redress their injuries because the government could take the same actions under the arriving in authorities. Okay, so in other words, they're suing under the email and the memo, but they're saying all those we're doing is just saying that we're going to do things a certain way. We don't even need those. We already have the powers in this other section of American law. Now, at oral argument, we asked whether that meant the government lacked standing. Okay, so if you're saying that you have other powers, can you even be here? What's the claim? What's the controversy? Is there anything that's being challenged? After all, how could the district court stay harm the government if the government is free to continue to do what it wants? Like, you're not going to be harmed. So why are we even here? Now, despite our questioning at oral argument, we conclude here the government does have standing to appeal. And for Trump and the government to now establish standing, it must show that it was harmed by the order that was entered. What is harm? It's an injury that's fairly traceable back to the judgment by Gouveia. But for the plaintiffs to establish standing, they must show that their injuries would likely be redressed by the order requested. Okay, so they're saying everything will be fixed if you cancel the email and you cancel the memo. They're saying, not really. There's a whole other section of law that allows them to do this. So that makes a difference here because the order requested and the order entered may be different. And the order entered by Gouveia is plausibly read to block the government from relying on the regulation, authorizing the government to fast track the parolees via expedited removal under the arriving in authority. Now, if that reading of the order is right, the government has suffered harm because the law and the arriving in authority is not based out of the memo, it's based out of statute. So the authority on which the government would rely and other parolees to expedite removal would have been divested from them and caused an interference with the government's ability to enforce immigration laws as they understand them. And the fact that the scope of the order is unclear does not cure the harm, especially not when the order is nationwide. She could have just cabined it to DC, but she didn't. She wanted to stop this across the board. So the order requested is different. The Undocu-Black and the CASA and immigrant humane rights groups did not request a stay of the Code of Federal Regulations. Wow, so that's like just bad pleadings. Thus, the order they requested would permit the government to continue subjecting them to expedited removal. They only sued on like one half of the power and didn't capture this other half. And as we explain later, that dooms their theory of standing. Now, although we have jurisdiction over the appeal, the plaintiffs have failed to meet their burden to demonstrate standing. Start with their theory. As for injury in fact, they assert that being subjected to expedited removal rather than formal removal is an injury. So we know you can remove us. We're just mad that you're removing us so fast. As for causation, they say the memo and the email will cause that injury because parolees have been subjected to expedited removal proceedings at higher rates after the emails came out. Like they really ramped it up. Finally, as it goes to redressability, how can we fix the harm? They claim that this follows from causation. The ICE memo and the ICE email increase the removal rates, and that caused the harm. So if you eliminate the memo and the email, that will reduce the harm and redress their harm and solve the problem. That would lead to a drop in expedited removals. But leaving aside other potential problems with their theory, we note a fatal redressability problem. Even if the number of expedited removals increase because of the memo and the email, that doesn't mean that getting rid of those two things is going to reverse this. As all acknowledge, the stay that they requested would not impact the government's authority to continue subjecting the plaintiffs to expedited removal under the Code of Federal Regs. The regulation permitting the government to subject parolees to this proceeding. And the government may well decide to exercise that authority given its enforcement priorities, which even the plaintiffs see and recognize. In their brief, they noted that expedited removal of parolees increased following the daily arrest quota that was passed by Deputy Chief of Staff Stephen Miller. Shout out. And so thus, absent more specific allegations, we cannot conclude they've addressed redressability. In other words, we can give them everything that they're asking for, and it's not going to solve the harm that they're claiming is being done to them because they failed to include a broader complaint. And so it is perhaps possible that GIA's stay of the Huffman memo and the ICE email will redress their injuries, but they have to show that. First of all, that it's likely, not just possible. They have to show standing that this decision will fix it, and they can't. And the plaintiff gives no basis for thinking that their susceptibility to expedited removal would be reduced in any cognizable way, given the fact that there's a whole separate power that they can use. So that is especially so given that after the court stay of the memo, the government has continued to expedite removal. They just changed it from the memo and the email over to the Code of Federal Regulations. And both of their arguments fail as we come to the close here. First, the undocu-blacks and CASA and immigrant groups, they say that even if some expedited removals will continue, the district court stay will decrease the rate of expedited removals because parolees were subjected to expedited removal proceedings at higher rates after the memos dropped. But given the fact that they can use this other power, the regulation permitting the government to remove them, the plaintiffs have not shown that this will decrease the rate. Instead, they've argued the government rarely relied on this in the past, saying, well, they didn't use that before, but they're using it now. Regardless of the past, it's undisputed that since the last year, the government has been relying on Section 1.2 under the CFR. And given the recent history and the government's new enforcement priority to expedite the removal, they have failed to show that the government could not or would not continue to rely on 1.2. And secondly, their argument is that the government cannot rely on Section 1.2 because it's unlawful. But that fails too. You didn't even bring your claim seeking a stay of that. So the requested relief would change nothing. We can give you everything. You didn't even ask for it. Now you want us to just kind of throw that in there? The only thing that might change something is the lower level court's opinion accompanying its order, which might persuade the government that 1.2 is unlawful. But redressability requires the court to afford relief through the exercise of its power, not through persuasive or even awe-inspiring effect of the opinion explaining the exercise of its power. It's got to be clear and articulated. It can't be speculative and like a shock and awe, like, wow, that's a good argument, so I guess we won't do that anymore. And so ultimately, they cannot seek relief that changes nothing for them. So they tried to do that. So here we vacate the stay issued by Judge Gia the Cobb, so ordered, and Gia once again is reversed. But again, not before she stalled this out. Okay, so from their perspective, this is a victory because in one manner, they stopped expedited removals. Even though the government just kind of pivoted and shifted over to using these other powers, they were not able to do it at the same, you would argue, speed and heft because she blocked them for a long period of time until they ultimately had to, reconfigure their strategy and pick up the pace again. So all of this has been being litigated for a long time. Gia the Cobb just blown out again. And we're also seeing that the government and Homeland and the Trump administration are picking up the pace on these removals. In fact, over 1,200 illegal aliens just got arrested in Georgia. There was a massive operation out of Atlanta in Fannyland, including arrests of heinous criminals with convictions for sexual battery and cruelty to children, which is basically the Democrats' entire political party. Under Trump and Mullen, ICE is not slowing down. We will continue to hunt down and deport illegal aliens from our nation. And here is this video.
A massive ICE operation led to the arrest of over 1,200 illegal migrants. Over 700 of them had either been convicted or charged with crimes in the U.S. Take a look at just some of those arrested with criminal histories, including sexual battery, aggravated assault, domestic violence, and cruelty to children. Here for that Fox and Friends exclusive is the head of ICE's Enforcement and Removal Operations, the ERO division, is Marcos Charles. Marcos, thanks for joining us. Tell us about this Georgia operation and what it netted.
Morning, Griff. Thanks for having me on the show. Look, as you said, we arrested over 1,200 illegal aliens out in the Atlanta, Georgia area. More than half of those people had criminal histories. And as you said, we're talking about sex crimes, assault and battery, some with DUI convictions, even domestic violence. These individuals needed to be taken off the street, not only because they're criminals, but because they're here illegally in the United States. I'm very proud of the men and women of ICE, ERO, that are out there on the streets every day making these arrests and keeping our community safe. It was a tremendous success out in the Georgia area. The majority of these arrests were in the Atlanta suburbs and city, but these arrests were going on throughout the state. And not just that, I mean, this one operation, as I said, was a great success. However, every day the men and women of ICRO were out in the streets across the nation enforcing the immigration laws as set forth by Congress. So we're keeping the community safe. Yeah. We're going to be traveling all over the United States doing the same thing.
All right, and that's good news. We don't want illegal aliens in the country, especially not criminal illegal aliens. And that's a big number, 1,200 of them now getting arrested in Georgia. And how many more are there? A lot to go, but this is a good development. And there's a lot of naysayers out there, nothing is happening. This would never be happening under Kamala Harris. There would never be expedited removals. There would never be the cleaning of voter rolls to get the non-citizen voters off there. And so this is all positive, and we're happy to see the pace pick up. We had billions of dollars just get appropriated over from the latest reconciliation bills into ICE and Homeland Security. And so the deportations will continue until territorial integrity improves. And the president is explaining why that's so important. We have all of these people coming here, waving their foreign flags around, telling us how to govern America, what it means to truly be an American, why we need to get rid of the First Amendment, why the Second Amendment needs to be repealed, why more benefits need to be provided to the disenfranchised migrants or whatever at the expense of the American public, why they need housing, education, food, every single thing you can think of paid for, discounted college tuition, grants, and more. All of it undermining the citizenry of our own country, of our homeland. And the president gets it. Here's what he said.
These are people that have been not successful. They're people that have been, in many cases, failures. They come from other failed countries, and they come here and they tell us how to run our country. They come from places like, I won't mention because I don't want to get myself into a controversy, but they come from countries that are not great. They come from, let's say, as an example, Somalia. They come in and then they tell us how our Constitution, how our Declaration of Independence, how it works. It doesn't work that way, and they're not smart. They have no aptitude. They have nothing going, and they're telling us how to run our country. And I just don't think it's going to happen. These are people that have been.
He's right about that. And it's always so wild. It's like you taking business advice from somebody who doesn't have a business. Let me tell you how to run your business. Do you have a business? No. Have you ever run a business? No. Do you know anything about it? No. But I'm going to tell you how to do it. Where'd you learn about that? Well, I just want it to be that way. And I think I know better than you do. If their values were in alignment with our nation, then wouldn't you see some evidence of those values in their home countries? Wouldn't you see some free speech articulated down there, or some due process, or some actual competent governance? You don't, which is why they come here. And then as soon as they get here, now they're real Americans because they got a piece of paper and lied on their naturalization forms to get in. So of course, we're happy the president is communicating the truth about this, and it makes a lot of people uncomfortable because you might be labeled a bigot or a xenophobe or anti-immigrant. Meanwhile, you'll stay silent to not be labeled in that category as your country is being stolen from you and your progeny, and as your taxation continues to increase in the form of inflation, diminished jobs, suppressed wages, more benefits being paid out to sanctuary cities, and your birthright in the form of a democratic representation and a process where you get to govern yourselves being stripped away as non-citizens are put on the voter rolls. The whole thing is a gigantic scam, and we're happy this administration is taking some action on it. And judges appointed by Joe Biden, like Gia the Cobb, now getting reversed and blown out in the District of Columbia by the Court of Appeals, not after she tried to insurrect the judiciary with her terrible, illiterate decision making. So we're going to keep our eye on more deportation news, but the fast track is back in business, boys. And so we're happy to see that happen. And hopefully they accelerate aggressively. We'll be here covering this. Thank you for joining and subscribing as we do. All right, now let's pause. We're wanting to see if the Tyler Robinson defense brief is out. And I do not think that it is. But that's okay, because we've got a whole nother story here queued up. But I just wanted to do a refresh on the docket here to see if it has dropped. It's about 4 o'clock over in Utah. So let us log back in because it times you out. So we're going to log back in on this and then see if this brief dropped. This is going to be a big brief. This is in response to the government's brief. So a lot of people have been waiting for this one. And it may be fresh out of the oven today. The deadline was today, but it may not be a 5 o'clock deadline. So we don't know. So we're logging back in. Then I'll show you the docket. Got to pass the CAPTCHA if I can figure out how to do that. Think I got it that time or not. Let's try this. Make sure my password is right. Trying to log in on this baby. For some reason, it's not logging in. All right, so this isn't working. Okay. I think I had a typo. All right, we're in. All right, so we're going to take a look at the Tyler Robinson docket here. Let me grab the case number. We'll do a quick search and then we'll see what they've got for us. But I don't think it's been released yet. If anybody has seen it, let me know. But we got another segment, then we'll see if it drops. I'm kind of anticipating they squeeze it in right before 5 o'clock Utah time, and then we'll get into it. So we're going to go to the Provo District Court and do a search right here. And 20 cents. We got the Tyler Robinson case. This is what it looks like. And it's loading. So let's see what comes out here in a moment. If it has dropped. Loading. We're live. Utah. 4:03 p.m. in Utah. So it might be skidding in here in a minute. But we have another good segment that we can hit if it is not available. But I would imagine it's going to drop like in the next hour. All right, there it is, just loading and loading. There we go. All right, so very busy docket. Let's scroll all the way down on this bad boy. See if we've got anything that has now hit. Nada. All right, so last filing was a restitution notice, memorandum in support of the preliminary hearing bind over. That was from the prosecution back on 7/28. So the defense should have theirs in today, but it might be a little bit longer. Has not hit yet. So we'll come back. We'll check that one out in just a moment. But we have another very interesting story that has dropped. And this is a curious one. And let's talk about this one right here. A surrogate is now fighting for the life of her child. We've got two people who hired her to grow a baby for them, and they found a problem with the baby's heart. Now the parents, so-called, who hired the surrogate, do not want the surrogate to give birth. They want to force her to have an abortion. And the battle has now emerged from Alaska to California and now over in Texas, where Ken Paxton is saying he's going to intervene to fight to save the unborn child who is diagnosed with a treatable heart condition and is now demanding that Dallas hospitals provide life-saving care. And so the story here is wild because this woman is now in love with this little baby that's growing inside of her and is fighting tooth and nail to save the life of the child. But the biological parents are saying, no, you have to end it. They pushed her to abort the baby after he was diagnosed with a heart condition. Her name is McKenna West. She lives in Alaska. She's a single mom of two. She signed on to become a surrogate with the worldwide surrogacy specialist in September 2025 just to make ends meet. She underwent an anatomy scan at week 20. They've got baby Gabriel, who's now been diagnosed with HLHS, a severe but treatable heart condition, per the lawsuit. And so she went into Alaska to say, don't make me abort this baby, and essentially lost. Then the parents sued in California saying you have to abort the baby because you signed a contract. And so she's now fled to Texas, and the Texans are now protecting her under Ken Paxton's leadership. Here's what we see is that the biological parents, we now know their names. They were referred to under pseudonyms as A, B, and CD. They demanded that West abort the baby in accordance with the abortion on demand clause of the surrogacy agreement. Now, doctors in Alaska refused to perform the abortion. They said, we're not going to do that. This baby is too old. It's a 2-day-long, highly intensive and risky late-term procedure. So then they demanded that this woman travel over to Seattle because they'll just kill anything up there. West already bonded with the child. She was grief-stricken at the process, saying, wait, you're just going to kill this thing? Like, I'll take care of it. She was appalled at the idea that doctors would inject baby Gabriel with a solution that will stop his heart, and then he'll be literally ripped apart and dismembered before being ripped out of the uterus. Every life matters, she told the Post. No woman should be forced to end the life of the baby that she's carrying, including me. Newborns diagnosed with this condition require surgery almost immediately if they need to survive. Babies who are operated on, though, have a 75% chance of making it to 5 years old, and those who make it to their first birthday have a 90% chance of making it to 18. This is according to New York Presbyterian Hospital. Here's Miss West, and she was an Alaskan nurse. She said, I can't go through with this abortion, and I will take full responsibility for baby Gabriel, and the biological parents will have nothing to do with this. But her offer was rejected, and the parents sued her for $250,000 in an amount that they would bankrupt her. So she fled to Texas, is going down to a hospital there, saying the hospital will deliver the baby, and then the baby will be operated on. And this is a complex legal battle. So then the parents went and they sued in California. They're trying to compel her to have California order her to go give birth in California where they live. Figures. They also are fighting to attain parental rights over baby Gabriel, who is then due on September 3rd. But West suspects that the ploy by the biological parents to terminate this baby is just to say she has to go to California, the baby will be born, and the baby will die outside of the womb because they won't operate on it. West has offered to renounce any parental rights over baby Gabriel as long as you give him surgery. Okay, so I'll give this child back to you, but you have to save him. They refused to do it. They've also discussed palliative care for their child with the doctors, according to court documents. But they say, no, she's distorting reality. She just wants their money. And the lawyers are coming out, and it's been a lot of back and forth. Now, unfortunately, the complaint said there's no way to know if the child will be eligible for the surgery because West refuses to submit to prenatal tests, and she's afraid that she's not going to get paid. Okay, so the parents are now suing her, saying that she's actually not cooperating with them. So this has now gone over to Texas, and Ken Paxton just released this today. He said Ken is now intervening in the Dallas County parentage case to protect the life of an unborn child who's expected to be born imminently with a serious but a treatable condition. The Office of the AG has also formally notified the Southwestern Medical Center at UT in Dallas of their legal obligations. Okay, so this baby comes out, you have to save this. You have to give this child medically necessary life-saving care. The child is known as baby Gabriel, diagnosed in utero with a hypoplastic left heart syndrome. Typically, there's 3 surgeries for this, and based on the information, they were diagnosed back in 20 weeks. After learning of the diagnosis, his intended parents demanded mom abort the baby. The surrogate mother reportedly refused, then went to Texas. She also sought to ensure that Gabriel could be near doctors that would actually help him. And the parents, according to Ken, have refused to agree that they will consent to life-saving surgery and may attempt to take the child out of Texas to prevent the treatment from being administered. So the child will just die naturally. It'll be a post-birth abortion through lack of medical intervention. Now, Paxton has filed an intervention in the case and asked the district court to enter orders directing the child's care upon birth, saying, Judge, order the hospital to save this kid, prohibiting his removal from the state and setting an expedited hearing on any refusal of treatment. In a letter sent to the hospital, Paxton laid out the independent legal duty of the hospital. Regardless of parentage, you have an obligation to try to save this child. The letter makes clear the physicians may provide baby Gabriel with emergency life-sustaining treatment, and that comes with or without parental consent or a court order. It's like your duty as a hospital to try to save this kid. Attorney Paxton urged the hospitals to provide life-saving care and reject any unlawful transfer of the baby out of state. Gabriel deserves a chance at life, and I will not allow anyone to unlawfully deny him necessary care. My office will use every tool available to protect innocent lives and ensure that every child receives the care that they need. And so they're going to continue to monitor the case, and this is now advancing. And they've identified the parents. You can see they identified them in the lawsuit, which is happening right here. So you see Texas submitted their brief, and McKenna West is the surrogate mother, and she has the baby growing inside her, baby Gabriel, as the defendant. So now you see that the parents sued, and this is now Sheen Gilkar and Omar Ahmed, who are presumably the biological parents. And my understanding, I did a quick Google search on this, but not a lot of research, is that it is female and male. Okay, so it's a female and male. Don't know exactly, what the biology is of the child. Is it the mom's egg and the father's sperm? They just did not want mom to carry the child, so they hired a surrogate. Or what is actually, happening? Is it maybe the mom does not have, viable eggs, so they got a surrogate egg and implanted one of McKenna West's eggs with the father's sperm? I don't know. But we now know who they are, and they had been proceeding anonymously for a while. And before we get to Texas, just back up, because in Alaska, this has been being litigated for a long time. And in Alaska, they were just known as A, B, and C, D. And what was interesting here is she lost in Alaska, which is why she had to now go and head on over to Texas. But even Alaska tried to intervene on this thing. They said, hey, this is the statement of Alaska's interest in this. The case implicates key questions about the extent of Alaska and the Constitution's right to privacy and autonomy. We are now submitting this because she got sued up there. Go abort the baby. Alaska says, what? Asking this question: can the court compel a woman to undergo pregnancy-related medical care with a provider that she would not ordinarily choose? Here, the Alaska Constitution protects the right of a surrogate mother to make deeply personal medical decisions, including whether to continue her pregnancy, where she'll receive the care, which doctors will help manage her pregnancy, who will ultimately treat her as she labors and delivers the baby. That's all to the surrogate mother. The constitutional right of privacy protects a woman's autonomy to make those decisions for herself, and it doesn't allow a contracting party like these parents, so-called, to empower them to contract away those rights, right? Like you can't say, well, I hate my life, so I'm going to pay you to kill me, and you can kill me, and there'll be no repercussions for you because I agreed to it and I signed on the dotted line. Although that is kind of happening in Canada and I think New York now. So saying in Alaska, you can't force her to give up one of these sacred constitutional rights. So McKenna West, this is Alaska speaking, is an Alaskan resident. She entered into a surrogacy agreement with a couple called A, B, and C, D, now known as Nasheen and Omar. When West and the couple signed the agreement, they included a forum selection clause saying that the state of Alaska shall govern this agreement and any legal proceedings need to occur there. She's left now. She's not there. While the surrogacy agreement contemplated West giving birth in Alaska if there were no complications, circumstances changed after the baby was found to have a heart problem. No hospitals in Alaska can do that. After declining the couple's demand that she abort the pregnancy, she went over to Texas where they can help. Near a hospital with medical staff that she's chosen to provide medical care during the remainder of her pregnancy. Hospital also has the expertise to save the child. Now, instead of honoring the surrogacy's agreement, the couple filed a lawsuit in California seeking to establish parentage over the baby. She filed a counter complaint in this court in Alaska, and the couple are now seeking an order here that, among other things, would order her to travel from Texas to California for continuing prenatal care, labor, and delivery. But they say, no, our Constitution guarantees of liberty are more protective than the federal Constitution. The federal Constitution just sets a baseline, but you can increase your liberties. The framers of Alaska had an emphasis on individual liberty, including the right to privacy. And it's more personal than one's body. And one of those things is medical treatment for oneself that Alaska protects aggressively. Now, beneath the broader umbrella, the Alaska Supreme Court has specifically said a woman's control over her body, including the choice of whether and when to have children, are embedded in the system. Any restriction that burdens a woman's right to privacy, including on reproduction, must be subject to strict scrutiny and can only survive if it advances a compelling state interest using the least restrictive means to achieve the outcome. And so all of this is very personal. And the state now has a compelling interest in appearing here when the contract is requiring mom to undergo an abortion. And so therefore, the state's position is that the court could not constitutionally enforce any abortion clause within the surrogacy agreement if the mom does not consent. Same principle extends to the decision of abortion itself. Saying all of this is medical. These are medical decisions, and a few things are more personal than a woman's control of her own body. Here, there is no dispute that the medical teams in Texas can help this baby. No one has argued that either West or the baby will be harmed in Texas, nor is there any dispute that West is able to make reasonable medical decisions for herself. She's competent. Now, the couple, though, the Nashar and Omar, they argue that it is better for them to provide ongoing care for the baby in California. Well, they'll abort you if you're like 10 years old. The state is not taking a position on the appropriate care after the born, but the unborn child is currently entirely dependent on mom, West. West has chosen physicians she knows in a hospital she trusts and a clinical team that will manage her pregnancy. So the order here would strip away those choices and require her to go to California there. She's got no relationship there. And involuntary medical intervention to force her to go get care in California is only permitted if there is no less intrusive alternative available. And so you must acknowledge that she is also a patient here. A surrogacy agreement cannot strip her of her right to control her own pregnancy decisions when those decisions are not causing harm. And any order from this court should protect her rights. And because the surrogacy agreement makes clear that Alaska law controls disputes, the court should enforce the Alaska Supreme Court's explicit protections for her decisions in this pregnancy. Ordering her to travel to California to undergo medical procedures that she's not familiar with violates her rights under the Constitution. Very nice filing by Jenna M. Lawrence. Shout out to her for jumping in on this case. So that's where we kind of left off in Alaska. Then we go over to Ken, and here's what he has submitted in his brief. Now, responding in intervention to get life-saving care for this baby. Plaintiffs Nasheen Gilkar, Omar Ahmed versus McKenna West, coming out of the Dallas County, Texas, 301st Judicial District, cause number articulated up above. Now, Ken says the state of Texas has filed a petition to intervene in this lawsuit, and we're submitting this brief. Under Texas law, a medical treatment decision made for a child over a parent's objection is the sovereign prerogative of the state. Okay, a parent can't say, I want you to let my child die. The state also has an interest in that human. So the state, therefore, also, just like Alaska, has a direct interest in this lawsuit. We want to identify and present the strongest basis for this life-saving treatment. Now, the question presented rarely reach any court. And so we have this case now that spans constitutional law, 4 Texas codes, 3 federal statutes, and custody law of 2 states. And so we're trying to assemble a roadmap, and we're not getting paid for this at all. So very long filing here. Let's hit the highlights on what's happening inside, courtesy of Ken Paxton. You see this just got submitted, and this story, I think, is about to break across the national news. Here is the statement of facts. Now, a child is about to be born in Dallas County. There was a gestational agreement, and the state is informed the birth is imminent. Mom resides now in Texas now, wants to receive treatment for the child when this baby comes. The intended parents live in California. The agreement says we all are to be governed under Alaskan law. We just got the back story on that. The child has a condition that will end his life shortly after birth unless he gets surgery. Now, surgery offers a meaningful chance of survival. If he survives, he will live with significant disabilities throughout his life. The parents have stated that they will refuse to consent to the surgery and they will allow the child to die. The intended parents may instead arrange air transport of the child to California in the first week of life, so then they can decide under California law rather than Texas law. Okay, so baby comes out, baby's like, going to die quickly unless they act on it. The parents say, well, put him on an airplane, send him over to us, and then we'll do what Californians do. So the record before the state does not show whether any Texas court has validated the agreement or whether any California court has entered a parentage judgment. And so a lot of questions here. Can the state participate? And does that question control relief? So can Texas intervene? Who makes medical decisions for the child right now? Is it the gestational agreement? Is it Alaskan law? Is it Texas law? What if the child is born in Texas? Does that control? Can the decision maker decide to refuse life-saving care? Parents hold a fundamental right to their child's medical care. Texas and federal law treat the refusal of this as neglect. Like baby comes out, you refuse to treat this child. That's medical neglect. May any parent refuse surgery? Is this something you can do if you know the child will die? And what this court must do to protect the life of the child? What happens if they try to transport this baby out of Texas? So he says, man, this is big. This case arrives looking like a simple contract dispute for surrogacy and kind of, trafficking in babies, essentially, paying someone at a disadvantage to have a child for you. It's the whole system's insane, which is why the Europeans don't do it at all. It's largely banned because it's trafficking of babies. But it is not one. It's not a contract. Once the child is born alive in Texas, he's going to be a legal person, and Texas will protect the life without regard to the circumstances of any contract. The question the court must be prepared to answer is not whether a gestational agreement is enforceable. The question is whether any adult, whatever parental title he holds, may decline life-saving surgery for a newborn who can live because the child will live with disabilities and they don't want to deal with it. 80 years of Texas law all say no. You got to treat the baby. So a brief orientation here will assist with this. Writing, a gestational agreement is a contract. A woman agrees to carry a child for other people. The statute calls women who give the birth gestational mother. Texas enforces these agreements, but only when a Texas court has validated the agreement. Nothing in this brief questions these agreements. Texas law welcomes these things. Now here, however, the intended parents propose to do one of two things. They may refuse to treat in Texas and let the child die there, or they may place him in an air ambulance, send him to California, and let him die there. Texas law governs both of these. We're going to address both of these in turn. First, they explain, Texas is here before you. We're allowed to intervene. We have rules, and we could have brought this suit in our own name and just sued these people, but we didn't. We're now intervening and you should let us in. And second, Texas law governs all of this. A child born in Texas is a complete legal person. And the mother, who is the gestational mother, is the child's mother unless a validated agreement or judgment provides otherwise. And Alaska's choice of law clause fails in Texas. and we're going to say Texas is the child's home state of birth, and we have jurisdiction. So we're not going to even care about what Alaska says. Contract says we should litigate there. We're not going to do it. The baby's here. It's our business now. Third, whoever the parents are, the refusal to consent to treatment for the child exceeds their authority. They can't do that. The constitutional tradition that protects parental child rearing has always stopped at the same boundary. Parents may make martyrs of themselves. They may not make martyrs of their children. Texas has enforced this since 1947. And the state, as parens patriae, may resolve a dispute in favor of a child. And this runs on a long single axis. And so fourth, federal law also compels the same result. There was a Capta Baby Doe amendment, and Texas accepts that, says that there is a law to prevent the withholding of medical treatment from disabled infants, okay? Not allowed to withhold treatment from disabled babies. The anticipated refusal meets the definition and applies here. And fifth, Texas law places every needed tool right in this court's hands. If the child's condition is emergent at birth, physicians may treat them immediately, and it's mandatory. Mandatory reporting, immediate investigation, emergency possession, conservatorship, and more, and even appointments of guardians ad litem. We can also get an order to bar the child from being removed from Texas. Now, sixth, the transport gains in the intended parents nothing. So they say, well, just take the baby over to California. But removal cannot defeat Texas's jurisdiction in order to achieve neglect. Flight changes the courtroom, but not the outcome. And six, the state asked this court to appoint ad litems, enter the treatment. So like, third-party lawyers to really represent the baby, enter the treatment and anti-removal orders and fix an expedited hearing protocol on an emergency basis effective the moment the child is born. If that structure is not in place, then we think you can get it in place. So, long filing here. Let's see. First section is about proper intervention, so a lot of legal stuff there. But they say, ultimately, we have standing to come in here because we want to save this baby's life. The state has an interest in its citizens and the people who are there. So we have a right to come in. And we'll fast forward through that section. Let's see if there's any other interesting sections in here. Texas is the forum. It's the child's home state from birth. And so we have emergency jurisdiction. And this is an interesting one under Section 3. Parental authority has never included the power to refuse life-saving treatment. A child can live here. There's a fundamental liberty interest here. Texas jealously guards these rights. And so in this case, the presumption fails where the child's health is jeopardized. And the rights of whomever is ultimately determined to be the child parents are real, but so are the limits. This is 80 years old. It's never been qualified. And they wrote this back in a case. It says parents may be free to become martyrs themselves and kill themselves, but it does not allow them to make martyrs of their children before they've reached full age and have discretion. So an adult, in other words, may refuse treatment for herself, but no case extends that liberty to refusing treatment to save one's child, and case law forecloses the extension of that. In fact, in 1947, the County Court of Appeals affirmed an order removing a gravely ill child from parents who opposed medical care, went and got the baby, and that is good precedent. The modern cases carry that forward. More litigation, and ultimately, outside of true emergencies, the proper course here is court intervention when providers and parents disagree about proper treatment, citing other case law, and they articulate what the parents' duties are: protection, discipline, support the child, and including giving them actual medical care. And this is a law that says you can actually have a child fatality statute that says medical neglect can be charged as a preventable death. And it's a felony in the first degree to cause injury to a child by omission where a duty of care exists. Oof. So we've reviewed these decisions. They organize cleanly. Courts intervene where treatment offers a realistic chance of survival. Courts defer where it does not. No third-party principle explains any of this. So the intervention line is broken across 7 decades. Illinois ordered a transfusion for an infant over religious objections. New York ordered corrective surgery for a boy whose condition was disabling, though not immediately lethal. New York ordered spinal surgery. Massachusetts ordered chemotherapy for a 2-year-old and transfusions. Colorado, Ohio, Oklahoma, Minnesota, they've all done the same. And so this deference proves the rule. Save the baby. So placed on that axis, this case is not even close. The assumed facts here present surgery that physicians expect to save the child's life, the child who is not dying regardless, and a refusal grounded in anticipated disabilities. Every court to face those elements before have all intervened. And so you should allow that to happen here. Federal law supports the same arguments and counsels for the same result. 3 separate federal laws enforce this. Baby Doe amendments make state intervention mandatory, especially when parents refuse medical treatment for the disabled baby. So we get the argument there. Laws say we want to preserve life. Parents can't just say, we're going to let our child just sit there and starve to death. There are criminal penalties in some formations of those actions. And this court has everything that it needs right now. Not whether the law protects the child, but who, how, on what timeline, on what condition. Law is clear about this. We've got the DFPS, which investigates these things. And the first safeguard doesn't even require an order. Texas has implied consent to present treatment to the child. And there are other mechanisms that exist as well. And so ultimately, you should allow us to intervene and act accordingly. This court also holds independent authority to appoint guardian ad litems to argue and articulate the interest of the unborn child, and do not allow this baby to be removed. The transport plan changes the urgency, and no injury is more paradigmatically irreparable than a child's death. So let us treat this child here. Saying we've got jurisdiction, very detailed. I mean, they really put together a nice brief here. And the neglect exclusion does not shelter the plan. And the criminal exposure is real. There we go. Once a custody suit is on file, taking the child out of the area and abandoning or endangering the child or causing injury by omission carries its own penalties. California adds parallel exposure on landing. Every step of the transport pushed this baby and the parents who are moving the baby further into criminal liability. Anyone who assists them maybe could be charged with crimes. So the child will be born imminently, and the condition is emergent. If the intended parents refuse indicated care, the hospital documents the refusal, the treating team reports it, the investigation opens. If the refusal holds, then the agency can take possession of the child, get an ex parte order, have a hearing on the first business day, and it's fast, it's blunt. We can actually get an order to go save the baby. Now, what prospective orders from the court will add is precision. Like, you can do that now. We don't have to wait until after the baby comes out. We can get all this stabilized right now so that as soon as it comes out, boom, 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 we know what to do. Everybody can act. If the child has not yet been born when the court takes this up, nothing requires waiting. That's why we're here. What cannot be decided before the child is born is then assessed as soon as it comes out. If something changes, we can do that. But now Ken Paxton is intervening here. And there is no law that allows parents to invoke refusal of life-saving treatment for this child. Other cases explain the same. The contract, the gestational agreement, doesn't authorize the refusal. No private contract can transfer the sovereign power over a child's life. And there is no refusal that is authorized. And even if the argument is the child's going to die anyways, futility doesn't authorize refusal. The surgery is expected to save the child's life, and so you got to try. Similarly, religious liberty doesn't authorize the refusal because the state's interest is in preserving the child's life. That satisfies any standard of review. And so in conclusion, they argue from Ken Paxton. A generation ago, Texas's highest courts confronted parents, physicians, and a newborn whose life hung on a decision no one could responsibly make before birth. It resolved the case, saying that the commitment of the state to the child's life does not bend to private agreements. The premise decides this case too. The child is about to be born in Dallas, will be a person, a Texan, and the court's ward in the oldest sense of the parens patriae tradition. So the agreement in the contract cannot require his death. And because the birth is imminent, we need you to step in. Recognize our intervention, permit us to participate, hold that Texas law governs this, and Alaska's choice of law provision doesn't. Appoint immediately an attorney guardian ad litem for the baby. Enter temporary orders directing that upon the child's birth, medically indicated stabilizing and life-sustaining care will be provided. Enter a temporary order prohibiting the removal of the kid from Texas. Direct the treating hospital to immediately give notice of the birth, give an initial assessment, and then start the process so that they can have saving care as soon as possible. Adopt an expedited protocol. Call us in for live testimony. And if those standards are met, appoint these agencies and anyone else with authority and decision-making capabilities to decide what happens next. And any other relief as necessary, respectfully submitted by Ken Paxton in this case. So that just dropped today. I'm sure these two parents who want this abortion to happen are going to respond to this, but sounds like the baby is going to pop out any minute now. So we'll, of course, see what happens. They also sent another letter to the hospitals. So Ken sent this one yesterday saying, hi, lawyers for hospitals, Texas Southwestern Medical Center, and the Children's Health System of Texas. This is happening. I'm writing on behalf of Texas. Someone's going to be born in your hospital with a heart condition. We know the parents are going to refuse to consent to that operation, but I'm stepping in. There's a lawsuit that we just talked about, an old case that says you have an obligation to treat this person that's owed to him at the moment. So putting the hospitals on notice. If this baby pops out, you got to treat. No parents may refuse life-saving care for a live child. Only a court may override that refusal. And Texas has enforced this for 80 years. If a parent refuses consent, the authority to override that refusal belongs to the state and to the state alone. And where time permits, the proper course is court intervention. And we've entered these orders before. These remedies are available quickly. And in an emergency, you may provide life-saving treatment without parental consent and without a court order. There's no liability for doing that. This is a ductal-dependent problem in the heart. This means the child will die. We expect the treating physicians will take care as a matter of course and not be liable for it. Federal law also independently requires treatment, as we saw. You're not allowed to withhold treatment, no authority to withhold treatment if the child is expected to survive the treatment. And a refusal of consent is reportable medical neglect. And you cannot delegate that. If you fail to provide treatment, that means you're dropping below the standard of care. And don't transfer this child out of your hospital either. So big fight is brewing right now. And I wonder what her due date is. But man, we're praying for little baby Gabriel. Hopefully they can fix that heart as soon as he emerges. But all this is happening. We got Texas Tribune saying here in response that West has traveled to Dallas. There's a pending case in California, but details there are not clear. West, Gilcar, and Ahmed have not responded to requests for comments. So the biological parents, in whatever fashion they're parents, have not answered this yet. The state can override a parent's medical decision when it determines that it's necessary to save the child. The letter challenges the fundamental purpose of these agreements by saying you can't strip away life-saving care for a child in the agreement. Anti-abortion group called Texas, pro-life group called Texas Alliance for Life applauded the move. We are proud to live in a state where the sanctity of human life is actually cherished. That is from Amy O'Donnell. And so the battle is brewing. The Texas pro-lifers versus the California abortioners over baby Gabriel. And this woman just wants to have this baby, and the parents do not want that to happen. So going to be an interesting battle. I think that this story will continue to capture attention as the fight continues, but ultimately we'll see if they follow California, follow Alaska, throw mom on an airplane and send her over to California so they can have this baby born and then just kind of, bleed out on the table, which is just sick. So shout out to Ken Paxton. Shout out to our friends in Texas, and prayers up for little baby Gabriel. Hopefully can save that little baby's life. But friends, we'll keep our eye on this story, and thank you for joining and subscribing as we do. All right. So that was a little bit of a heavy segment there, huh? All right. So let's do a refresh on the Robinson brief. We may not get it today. Maybe it's a midnight deadline and it's going to come out in the future. But let's take a look. Let's do a refresh over here. See if I can spell my name right. And we'll log in to see if we've got anybody seen this drop yet. I don't think it's dropped. So we may not have it today. But yeah, and surrogacy in many other nations is just completely banned. It's not even allowed, which makes good sense to me because it's like trafficking in humans. And for some reason in America, it's like, oh, it's just a contract. What, do you hate capitalism? No, we hate babies being implanted in women who are then stripped from their mothers and sent over to some other families. Okay, that's the wrong search. Who didn't grow that child? Anyways, all right, let's do a search over here, see if we got anything cooking. In the Tyler Robinson matter. Yeah, we just had a baby. Man, so it's just like it hits different, But yeah, let me show you like the European, while this is loading. Let's see. Okay, that's just loaded. Surrogacy laws by country. Let's see if we have a chart here. Largely not allowed. Let's see. Brazil, banned. Canada, only altruistic surrogacy. China, banned. Colombia, no clear rules. In Finland, all surrogacy arrangements, both commercial and altruistic. I think altruistic is like you have, like your sister will carry your baby. It's not for money. It's just like, I'll do it because you can't have a child, right? Your sister or somebody does it. Finland, banned. France, since 1994, any arrangement in France, according to civil code, commercial, altruistic, that relates to procreation or surrogacy is void, no legal effect. It is not sanctioned by law for women who give birth, but legally sanctioned. Germany, all surrogacy arrangements, both commercial and altruistic, are illegal. It's all right here, right on Wikipedia. Here, I'll show it to you. I don't know why we deal with that here. I don't know what the deal is. Germany, all surrogacy arrangements are illegal. There you go. Greece. Surrogacy in Greece is fully legal. One of only a handful of countries in the world to give legal protection to intended parents. We're another one. Hong Kong. Commercial surrogacy in Hong Kong, criminal. Iceland, illegal. India, only a couple who's been married for 5 years can opt for surrogacy. Indian men and women. Ireland, no laws. Israel, legalized surrogacy. First country in the world to implement state-controlled surrogacy. Iran, it's legal and popular. In Italy, any form of selling embryos as well as surrogacy is prohibited. In Italy, you go to jail. Shout out to the Catholics. Its legitimacy was confirmed by the Italian Constitutional Court because the practice of surrogacy constitutes an unbearable attack on women's dignity and deeply undermines human relations. Couldn't agree more. Japan, there was a proposed ban, but it's unregulated right now. Mexico, unregulated. Netherlands, Altruistic is legal, but commercial surrogacy is illegal. New Zealand, altruistic. Poland, mostly unregulated. Portugal, under certain conditions. So like France and Italy, so some European countries, Germany, illegal. Can't do it. Saudi Arabia, no. Serbia, Slovakia, South Africa. Switzerland, illegal. Article 4 forbids surrogacy. So another European country. Ukraine, a major surrogacy destination. Well, that's curious. UK, altruistic in England is legal, but commercial surrogacy is not. Again, illegal. So yeah, we're one of the only few Western countries that does it for whatever reason. All right, so let's do one final update on Tyler Robinson, and we'll see if there is a brief here. As soon as we end the show, it'll come out. But not. All right, so don't have anything on that. My apologies. I thought it would drop while we're here. It might just be due, later tonight. I was kind of thinking it'd be 5 o'clock. It's 7 o'clock here, 5 o'clock in Utah. But no updates on the docket. All right, so we may have to come back on that one tomorrow. But now, my friends, let's hear from you. If it drops as we're wrapping up, we'll hit it. But today, we had a great stream. Thank you for joining us on the day. We saw the president was kind of trolling a little bit with a national election emergency statement. Stranger things have happened, and that caused a 5-alarm fire across all the leftists. Democracy docket. Trump is plotting to take over elections. And of course, the argument that was cited was about emergency powers and how Congress only has so many abilities to undo those declarations of a national emergency. Talked about that from an old article on the Washington Post. We then saw Congress is firing off a bunch of letters over to IDEMIA saying, Mikey Sherrill is blaming you guys for our illegal aliens on our voter rolls. What say you? And they got a couple of updates. Harmeet Dillon got a letter from Congress. America First Legal is launching an investigation into New Jersey using FOIA laws, essentially state-level FOIA laws to get into it. Trump says, we want the SAVE Act. Then we had a big win. Judge Gia the Cobb got slapped down in her battle to prevent Trump from enforcing immigration law. The D.C. Circuit Court of Appeals just said, you lose, so ordered, and her stay has now been vacated. And so she's now lost again. We then heard from the president saying, we also saw in Georgia, they've arrested 1,200 illegal aliens. And Trump says, not appropriate to come from a foreign nation that in many ways is a dumpster and then tell us how to govern our own nation. We don't appreciate that. That's a rude thing to do. You walk into someone's house and say, I don't like how this is set up here. Your fashion's terrible. I'd put that over there. Get out of my house. You don't even live here. So I agree with him completely. Then we talked about this surrogacy case, which is brutal. So mama wants to save baby. Parents want to say, no, abort the baby. Texas now stepping in. We've got Alaska, California, Texas, federal law, all coming to a head. And the baby is apparently going to be here any day now. So baby Gabriel, hopefully comes out and is healed quickly and lives a nice full life overcoming this battle. But now, my friends, it is time to hear from you and see what you have to say about all of this. We'll fix the title. Sorry, there was no Tyler Robinson today. We tried. Well, let's see who's here and joining us. I see some good friends in the chat. Nice to see everybody. Thank you for being here and for joining us on the Tuesday edition of Watching the Watchers. Let's see. We got some comments and some donos here. Oh, what's up, Sandy? Nice to see you. Hey, there's us again. Hey, what's going on, Jesser Bob? What's up, Jesser Bob? Rob, when I told our daughter you all had your baby and it was a boy, she grabbed her hands together up by her cheeks and said, oh, a baby boy. Then when I told her you named him Cannon, she said that, hey, that means truth. Oh, man. How does a 10-year-old know such things? Anyway, super excited for your growing family. Thank you, Jesser Bob. Man, shout out to your 10-year-old daughter. She is smart, man. That's a smart statement. canon, right? It's referring to a body of works. It's referring to the canonists who really laid out the foundation of our common law back during the Middle Ages. And it's very astute. What a smart child, Jester Bob. You sound like a great parent. So thanks for saying that. Shout out to your daughter. We're excited too. And kids are just great, aren't they? Thank you, Jester Bob. Shout out to your 10-year-old. Geegum Geegum, sharing this one. Meme Smith extraordinaire, man. Thank you, Geegum, for sending this one in. Canon James Gouveia, welcome to the world, August 6. Brought by a heavenly stork into our arms. And man, I got to work on my biceps. Okay, bicep day is tomorrow, so I got to work on it. And probably get some testosterone and HGH if I want to get that type of girth over there. But Geegum, thank you for making me look good. I appreciate that. Not quite there. But you got Alexis's beauty perfectly. You nailed that one. And you nailed me too. I just got to, shoot up a little bit. Geegum, thank you so much. Meme Smith extraordinaire. Absolutely love that one. We're going to save it forever and ever. And you rock. Thank you for that. What's going on? Trump Sword in the house. 14 months as a member. Thank you, Trump Sword. Make sire to vote in each election and every election in your area. This is for all the marbles. 14 months as a member. Thank you, Trump's Sword. We appreciate you being here for 14 months, coming up on 2 full babies in the House. And it's a big election. If the Democrats win either house, and if they win both houses, we're cooked. So we can't let that happen. Rick D, U.S. Marine veteran Robert Gilman has been safely released by Russia and is now safely on a plane coming back home after 1666. I saw that headline, man. Shout out. Yeah, so Trump gets another American person held in captive released back home to the USA. God bless America. Love that picture. Unfurling the American flag. Lovely. Thank you, Rick D. Glad he's coming home. Sandy, Judge Talwani blocks Trump's EO on the USPS mail-in ballots. I feel like we covered that one some time ago. Let's see. Was this a new one? Wow, a new one. Amazing. So thank you for that. Interesting. Indira Talwani, the Obama judge out of Massachusetts. All right. Thank you for flagging that one for us. Saying Trump's postal service order now blocked. Yeah, typical. And Trump has won on some of those in other locations. But then they actually got the rule published. So maybe that's what this is about. But all right, we'll put a pin in that one. Thank you for that. Coming over from Sandy in the house. You rock, Sandy. Thank you. We also got this one from one old guy. Demonic situation, A, B, and C, D, a bunch of CDs. A bunch of corrosive demons. Oh, I see what you did there. You took the pseudonym acronyms, A, B, C, D, and just transmogrified it into a bunch of corrosive demons. Nicely done. Rick D, there it is. Indira Talwani, man, at it again. She's expanded her order against Trump's EO. She's terrible. We've been talking about her a long time. I think Obama appointed her. It was her and Sparkle. Both of them have been playing patty cake with each other on Trump's election EO. So we'll have to come back on that one. Thank you, Rick D, for the heads up. Quad Cam, hey, I'm a little late to the party, but congratulations on the new baby boy. Maybe if you use this dono toward Cannon's future law degree, then he can replace Ketanji someday. Yeah, that's what we're thinking. Chief Justice Cannon. Yeah, I like it. Much better than Chief Justice Ketanji, So I'm with you on that, Quad Cam. That's why we read him the Constitution when he was in Alexis's beautiful belly, so that it stuck in there. So he came out, with a head start. Thank you, Quad Cam. Thank you for the nice dono, my man. Yeah, we'll add that all into the new Trump account that we're working on right now. Hey, Biltong is here. King of Biltong, good to see you. Hey, did you know that Biltong makes exceptional travel food? I did, but did you? Clean, protein-packed, grass-fed, air-dried beef with great flavor. You can get yours at BiltongUSA.com and use code Robert, and you'll save 10% off and get amazing, delicious meat delivered right to your door. So check it out, Biltong USA. Thank you, King of Biltong. Hey, Michael Manson, what's up? 41 months as a member, man. Hey, thank you for being here, Michael. That's a long time. We've been through some stuff together. I got more gray hairs. For sure. Congrats on your newest addition to your family. Thank you, Michael Manson. And I got one of those shirts. My mama got me one, and Alexis got me these shirts that have like the kangaroo pouch out front. It was great. Used it for the first time today. I just put this little baby in here, and I just sat right here doing show prep with this little baby right in my chest. It's perfect. He loved it too. He just kind of conked out. He's like, oh, this is nice. I'm snuggled. This is great. So it's a lot of fun. Thank you, Michael Manson. And thanks for being here for 41 amazing months together. Hey, to Sadaka. The fight for medical treatment here is the antithesis of what we have seen from places in Europe, where the government has restricted parents from taking a child out of country for life-saving treatment. Oh, that's interesting. So in other words, like if they couldn't treat that baby in France, like they wouldn't allow the baby to go to England or something. That seems not good, you know. But I'm sure there's more to that story, but I don't know the details on that, to Sadaka. All I know is that many of them would just not even allow this contract to have been written and endorsed. But we do. And it's a wild thing. You know, you go through pregnancy and you see what it does to your wife, what it does to her body, what it does to the child. Like the baby, as soon as he lays on Alexis, there's a skin-to-skin reaction that happens. So the idea that you're taking a child, so you know, Miss West has this baby and the baby comes out. Let's say the baby Gabriel's healthy and they just like, you're gone, bye from mom. And you just go right over to like these new parents. There's something off there, I think. I just think that there's something off there. And I can't imagine it's good for the child, especially if it's not going to a woman. If it's going to like some dude, you take this baby from this woman. The baby should be breastfeeding and, you know, be on the mom and like be loving with this baby that grew her forever. And you just take it and you're like, here you go, dudes. Have fun. What is going on here? To Sadaka, thank you. I don't know. Jim tells you, hey man, what's up, Jim? You get your computer fixed? Hey, congrats, Rob and Alexis. Welcome, baby Cannon. Enjoy these days. Each one is a new, unique experience for all three of you. Thanks again for the raids. They've really helped me to grow my audience. Amazing, Jim. Hopefully you're having some great streams over there. Yeah, and I saw you had somebody mentioned that you had some computer problems, so hopefully you got all that fixed. We'll send some friends over your way today. And Jim, thanks for the nice comment. Friends, go check out Jim Tells You. Hopefully you enjoy the streams over there. I know you do. Chat with me. Wondering how you feel Fauci hiding miscarriage info might play in the election. I hear that many are angry. Which party will they likely blame? Yeah, it's a good question. I mean, I would think most of it would go to the Democrats. I mean, the Democrats are like frothing mad over any attacks on Fauci right now. I saw Margaret Brennan, one of the most scummy people, I think, who's on cable news, just shockingly disgusting of a person inside and out. And she is just, you know, like validating the jabs and just defending them tooth and nail to the very end. Won't even acknowledge that maybe some of what has been uncovered is true. It's all just, you know, misinformation. Won't even allow the arguments to proceed. I think she was talking with like Jay Bhattacharya or somebody. But I mean, I think the Democrats were the ones that were pushing the jab. Like Trump was on his way out when the jabs were released. He was trying to get them done before the election. There was some contemplation that they had delayed Operation Warp Speed to prevent that from happening. And then they ultimately came out, I think, December, right, of 2020. And then Biden came in, and then they really started to open the floodgates. And as soon as Biden won, the death counter scoreboard went down, and then the vaccination green scoreboard went up. Oh, swap that out. And they were the ones doing the mandates largely, or trying to impose mandates. They were the ones who were like purging the governments. I would think it's mostly about them. But, you know, you never know. But I hope it has an impact, because that's what they did. I mean, they really rammed that down everybody's throat. They knew it wasn't all that great and said, no one cares, take it. Chris Kinsey, the craziest judge in history is the judge in the 1670 trial of William Penn. Jury found Penn not guilty. Judge sent the jurors to prison until they changed the verdict to one that he liked. That's a crazy story. I'm going to have to look that up. That sounds like a very interesting thing that I did not know about. There was some wild stuff that happened back then in the early days. Very political. Like you talk about weaponized prosecutions and judges, a lot of that going on back in the early days. I'll have to look that one up. Thank you for the heads up on that. And here's one. Okay, so here's some more backstory. Alfie Evans is not allowed to leave the country. UK court says he can't go to Italy. Why would they do that? Like, what's the rationale behind that? Why can't a kid not go get treatment? They think he's not coming back? 2018 story. Wednesday's ruling rejected new arguments intended to overturn a decision by the High Court, prevented terminally ill toddler from leaving Britain. We have the right to appeal. Neurodegenerative disease. Was one parent objecting? Treatment was stopped. Parents appealed. Stirred the British public. Pope Francis said, let this kid go. Wild. They dismissed the case at the Supreme Court, rejected the plan to take him to Rome, and said the order to end his life support should commence by 9 p.m. We have some sick people who are in our government. They say, kill the kid, a grown kid, rather than let him go to Europe. Oh my gosh. Let him go to Italy. What a sick situation that was. It ruled to ban travel. Doctors say he can go there. We can help him. I mean, it's like, are we free? Like, are we free people at all? Or do we just have to follow the rules of our so-called leaders who say, no, you have to have your child die. Nothing you can do because we don't want you to travel because of some stupid rule. Crazy to Sadaka. I'm going to have to read more on that one. I did not know that. Shocking. It's like sick. There's like an evil thing that's happening in many places. Sick stuff. All right. So friends, we'll pause here on the day and we'll come on back tomorrow to get into, John says they would have to kill me. I mean, I totally agree. It's like, you're not going to let me take my child. You're going to order me to kill him, or I could just leave and go to Rome and get care. How do you not go on just a total rampage? How do you not just unleash hell? I don't know. But all right. So friends, it's been a lovely day and a beautiful stream. Let me make sure that we got all of the updates on the day. See if anything dropped on Robinson. And I'm not seeing anything. So maybe they just got to squeeze it in by midnight or something. I was kind of thinking it'd be a 5 p.m. submission, but we're now after 5 p.m. Let me do a refresh on this one. Did I get the date wrong? Maybe I just got the date wrong. Court location, Provo District, case number, beep, bop, boop, do a search. Tyler Robinson. I may have just got the date wrong, or it may just drop later tonight by close of day. But we're doing one final search. Yeah, and John says the moment you hit end, it's going to populate. No question. It's how it always goes. Let's see. Nada. All right, just so you can validate. Nada there. And it's now 7:04, so it means 5:04 in Utah. All right. Well, we tried. We thought we were going to squeeze it in. Sometimes we do. Sometimes we start the show and like the third segment is not available until we get to the end. And then it's like, could really use that document right now. And then it shows up. I'm like, oh, that was perfect. It all worked out accordingly. But not today. But presumably it will come out. I checked the date a couple of times today and it said it was due today. So it must just be later. So we'll come back on that. One old guy. Socialist medical system of UK. Socialism and communism are cults for Lucifer. I think that's a good interpretation. Yeah, a very good interpretation. It was the 1st of September. Let me see the dates. Today, yeah. East Idaho News, KSL News Radio. I know I wrote it down somewhere, but the news said, yeah, state had theirs due by July 28th, reply due today, August 11th, state's rebuttal August 18th, and then another hearing's coming back on September 1. So it should be out. So it'll be out soon. Here, this is what I'm looking at. Just so I can confirm I'm not a total dingbat here. Here's what this one looks like right here. KSL News reply August 11th, state's rebuttal August 18th, and another hearing on September 1. So that's good. All right. Well, not here for the show. So, all right. What can you do? All right. So, friends, we'll pause here on the afternoon. Jason Trades. Hey, congrats on the baby cannon. You are a great dad. Man, thank you, Jason Trades. I want to be. I do. I want to be a good father and wise and caring and strong and all the things. So we're working on it. I got some work to do. Fortunately, I've got, some years to grow, which is good. So Jason, man, thank you for being here for 26 months as a member. You're amazing. We appreciate that. We also had G-Gum. What firsts have you and Alexis experienced so far, Rob? Urine emerging out of a little toddler's genitals straight up into the air in like a surprise. So that happened. But we ordered some, they're called pee-pee teepees. Okay, pee-pee teepees. They're like these little, they look like almost like birthday party hats. It's like kind of like a cone thing. And apparently you just plop it over the little baby's, massive Johnson. And then you allow the baby to, it doesn't spray all over the place. So that was a big surprise for me. But I have to think about that, Jigam. So many good ones. But he's just been great. I mean, I think the whole thing was like a first for me. The birth, it was a home birth. I caught the baby right out as it came out of my beautiful wife. I cut the umbilical cord. The whole thing has just been just a never-ending thing of firsts. But the sprinkler urination was also a pretty good one too. But yeah, thank you, Jigam. I'm gonna have to think about that. I think a lot of it has just been first after first. And Jigam, there will be much more to come. We're excited about it. Now, we got Elliot. Hey, motion to clarify the preliminary injunction. All of this is on what's going on. Barbara versus Trump, that's the birthright case. We got new documents in this case? Oh, are they filing on Trump's executive order? Ah, okay. So they're kind of reinvigorating. Interesting. Thank you, Elliot, for flagging that one. So they're invigorating the birthright case, right? So Supreme Court comes back down for 14th Amendment applies to everybody, including birth tourists. And then Trump issued the executive order to include alien enemies. And so it looks like we got some litigation on that's happening now as well. Elliot, you're the man. Thanks for flagging that for us. New updates there. Perfect. Between that, Robinson, and Talwani, we're already jamming for tomorrow. So awesome stuff. Elliot, thank you for sending those in. And friends, thank you for joining us. It's been a beautiful stream. Happy Tuesday. Hopefully your week is unfolding beautifully well. And we're glad that you got to join us today. Hopefully you come back tomorrow because we're going to have a lot more to get to. And let's see. Neuro D, what's going on? Neuro D in the house. Sharing our watchingthewatchers.locals.com community. We had a great members only stream this morning. We talked about the Tate brothers and how they're trying to get out of custody. They've been filing motions for bond. They had some interesting documents released. They released their commissary receipts and got to see them buying Doritos and other things. The DOJ kind of, dragging a lot of that out. They're trying not to get extradited. We looked at, allegations from the DOJ, their flight risks. They've got multiple bank accounts in multiple countries. They've got multiple IDs. So I'm not sure a judge is going to give them a special exception to let them out, but we went through it. We also talked about, what was the other segment this morning? Oh, Mom Donnie. Mom Donnie just got blown out. So his pied-à-terre tax, however you say that stupid French word, just got crushed. So a Staten Island judge said, no, you can't do that. The leftist sued the other leftist communists. So the blues are mad at the commie. and they're suing each other. And so we talked about that decision, which is a lot of fun because the more they fight with each other, the better for everybody. Then Barb Schaefer, what's up? Thank you, Barb. Excellent show today. Thank you, Barb. It would have been better if we would have had the Tyler Robinson decision, but that, of course, did not come down for whatever reason. And still not out. All right. So we'll pause here, my friends. It's been a lovely day. Thank you for joining us. Thank you for subscribing. Thank you for liking the video on the way out and all the things. Thank yous to our amazing mods and meme smiths. We got Muffin Rando in the house. What's going on to John? We got Donut Mind Me in the house. We got Neuro D. We got Janik and Dog Digger. We got K Bean, of course, Geegum Geegum, Elliot, and just Rhonda, keeping things nice and orderly around here. And thank you for being here and supporting all the work that we're doing. Thanks for liking the video. Thanks for sharing the show. And thank you for returning back here tomorrow, because we will be back here to get into it again. And in order to do that appropriately, we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful evening. Sleep very, very well. We'll see you right back here tomorrow. Bye-bye.
Watching my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we exposed corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through